And I welcome all of you here this morning. So since 1940, at least 17 Supreme Court cases have either cited, considered, or relied on foreign or international law. There are also some, as an Oregon supplement in the materials that you've received, and we have an extra copy of it out there, which was put together by a great Lewis and Clark student, I don't think he's here, Jacob Wright, which tells us that the Oregon Supreme Court referred to Article 55 of the UN Charter to support its holding that the Oregon Alien Land Law, which applied only to Japanese residents of Oregon, violated the Equal Protection Clause of the 14th Amendment. That was a case that was decided, I believe, in the late 1940s. And in a 1981 decision by Justice Lindy of the Oregon Supreme Court, in a case called Sterling versus Cupp, the court examined a variety of international treaties and covenants regarding the treatment of detainees to interpret a phrase in Oregon's Constitution which prohibits the treatment of prisoners with unnecessary rigor. And in order to evaluate that, in order to figure out what unnecessary rigor meant, Justice Lindy again looked at various international treaties and covenants. So it's not totally unusual to talk about international law, and yet how many of us have really looked to international law for guidance when representing our clients? In fact, our clients, in some ways, may have a better sense of this than us. Sisters of the Road, which works with homeless and houseless people in Portland primarily, constantly refers to the right to housing as a human right and works to end poverty with key allies not only across the country but also internationally. And there's a group in Portland called the Partnership for Safety and Justice, which works on prisoner rights. And the spring 2006 issue of their newsletter, it's called Justice Matters, was a whole newsletter devoted to looking at issues in the justice arena as a matter of human rights law. So the National Lawyers Guild has had a long history of educating ourselves about international law and how to use it both in state and federal courts. In fact, when the Guild convention was held in Portland, and it was back in October 2005, we also did a CLE program titled Out of the Classroom into the Courtroom, How to Use International Law in Our Everyday Law Practices. But the idea for this program really emerged out of the Guild's hope to work better with groups in our legal community on these issues. And I think that there will be a couple of attorneys, at least from legal aid, here today. And this, our goal, I think, is to try to build up alliances, not only with, of course, legal aid and legal services attorneys, but also with others, public defenders, and all of you who may not necessarily work with the Lawyers Guild, and hopefully we can work more together on some of these issues. This group is also, this CLE is also co-sponsored by the American Constitution Society. Chuck Tomlin from the ACS is here. And we really appreciate their support. They've given us support to other programs that we've had. The American Constitution Society is a great organization, does wonderful seminars in itself, and if you're not members, I encourage you to go on their website and join. We've been able to fund this program in part through a grant from the National Lawyers Guild Foundation. And hope to have a video of the program posted both on the Portland NLG's website and also on the National Lawyers Guild, the national organization's website. So we're not naive about how courts will respond to raising international law issues in our cases. I don't know how many of you have ever done it or thought of doing it. I've done it recently in a case, which is a challenge to something called the no-fly list. And one of the issues, or one of the claims that we raised in that case, was that people have a right to travel, not just based on due process and on other rights to international travel, which the court has talked about as well. But in those cases, people actually leave the country and then are not allowed to return to the country. So we and these people are US citizens. So one of the claims that we filed was a citizenship claim, which basically said to the court that as a citizen, one of the rights you have as a citizen is that if your country allows you to leave, you must be allowed to return. If they're going to arrest you or whatever else, they can do what they want to do, but they cannot prevent a US citizen from returning to the country. And when you look at the citizenship clause of the US Constitution, needless to say, there haven't been very many cases interpreting that or creating that right. So we relied before Judge Brown on this issue or this right, going back as far as the Magna Carta, and also relying on the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. We didn't win on that claim, and Judge Brown was a little bemused by our raising this claim. But other claims are going on in that case. But there are different ways that you can think about using international law. And through this seminar today, hopefully that's going to become more and more clear to you. And we know that representing poor and working class and immigrant clients, which a lot of us do, the laws often works against us as for us. But if we can expand our toolbox in that advocacy by relying on international legal principles, and if we can educate judges as well as our clients and community groups we work with when doing that work, then perhaps our chances of succeeding in that work will at least incrementally increase. So that's kind of the theory of this workshop. I'm going to go over a couple of logistical things, and then I'm going to tell you about the amazing speakers we have. First of all, there are some people here who I think are not lawyers, who just work with community groups, which is fantastic, and we really appreciate them being here. And if we talk too much like lawyers during this program, don't hesitate. We have a small enough group that people should, raise their hands or blurt out, I don't know what you're talking about, please clarify. And we're happy to do that during this presentation. Wi-Fi is available. All of the materials that were put out are, I think you all have been given a link to that. There is a city guest Wi-Fi availability here, and you just have to click on it and you accept the terms, and then Wi-Fi will be available here. We're going to have a couple of breaks. We're going to do a coffee break at 10:15 and then a lunch break at 12:15. And there's actually a cafe in the Portland building that is great, and then there are obviously a lot of restaurants around, but we ask that you, when we call those breaks, hopefully we're going to stay on time, and that we try to stay on time in this program. We have to be out of here no later than 5 o'clock today, or our costs increase tremendously. So, those of you who are members of the bar, we are approved for 5.5 CLE credits. As long as you sign up on the sheet outside with your bar number, we'll provide that information to the bar, so you don't need to do anything more, but just make sure that you sign that. I'm going to encourage you, again, to join the National Lawyers Guild. The Guild, if those of you don't know, it's been around since the 1930s. We were formed at that time as an organization primarily because the American Bar Association did not allow African Americans to join. And that was really the motivation of the Guild forming back in the 1930s. We have an interesting history in Portland. A lot of people who you might not think of, like former federal court judge Gus Solomon at one point did work with the National Lawyers Guild and some other really big lawyers, Alan Hart. And we do have some information about the history of the Guild in Portland. We're happy to give you that information, particularly in the 1940s. We also encourage you, as I said, to join the American Constitution Society, and again, we appreciate their assistance, and just go on either of our websites, nlg.org, or whatever AC, or just Google American Constitution Society, and joining them is pretty easy. This afternoon, at 1:30, we're going to break into small groups, and how many will depend upon how many people end up showing up today. Some people have said they're coming late, and some people have to leave early. And we hope in those small groups to kind of take some of the stuff that we hear about this morning and think about it in some of the cases that we have. So again, don't be shy if you have any cases that you're working on right now. We encourage you to bring those up in the small group discussions. And we'll just do a little bit of brainstorming about different ways, maybe in which we can use international law and then report back and think about that and hopefully get something out of the program in that respect as well. And Lauren will give us a little bit, I think, some more insights about how that will work as the day goes on. And the final thing is Lauren does have some PowerPoint stuff and, is that what you call it, PowerPoint stuff?
Yeah.
PowerPoint slides. And she'll make sure that we have a link where we can access those as well, and we'll make sure that information goes to people who attend. So in terms of the people who are presenting, I'm almost done with my presentation here. We're pretty lucky to have two amazing primary presenters here today. One of the presenters who's going to be arriving a little bit late, she had to deal with childcare stuff, is Gwen Skinner, who comes close to being our biggest celebrity here today. Gwen is now the head of the Human Rights Law Clinic at Willamette University. She previously was the head of the similar clinic at Seattle University. I say celebrity because she just flew in from Geneva, where she was requested by the UN Human Rights Council to lead a seminar there on holding corporations accountable, and was actually just on Think Out Loud 2 days ago. You can listen to Gwen on Think Out Loud and talking about the recent CIA the recent disclosures about CIA torture. I'm not going to go into great detail about the backgrounds. They're in, again, the handouts that you have. But she has a lot of experience, particularly working, representing Guantanamo detainees. And we'll talk a little bit about the implications of using international law to do some broader human rights law cases. The one who's going to focus us, though, on how to use this in our kind of everyday law practices is an amazing young woman, Lauren Bartlett. Lauren is the director of the Center for Human Rights and Humanitarian Law at American University Washington College of Law in Washington, D.C. Managed to fly in last night despite the weather with her one-year-old child. And Lauren has been a former legal aid attorney, has done a lot of work in Louisiana, or worked in Southeast Louisiana Legal Services until 2011. She co-founded the Louisiana Justice Institute. For the last several years, she's been doing this work at American University and has been doing trainings really around the country, and has produced some amazing written materials. And the manual that you have, which is about human rights in the U.S. Handbook for Legal Aid Attorneys, can apply to all of us really doing work where we're representing poor people, working class people in the United States. She's also worked with nonprofit organizations, not just in the United States, but also in Nepal, Ghana, Bangladesh, India. And again, we are extremely fortunate to have her and really appreciate her flying all the way here. And again, we appreciate all of you being here. This is a new area of law. We hope to get more and more people interested, and we're looking to you to help us get people interested.
Hopefully this will be a very interactive day, so please feel free to interrupt. I think that many of you have examples of using human rights law or international law in your work, or you might have examples of local laws that I don't know about. Please just interrupt and add it in. I just heard that Thane was just in Bolivia. I'm sure some of you have some great things to ask, so please interrupt whenever you'd like. I'm going to try and make this presentation as practical as possible, focusing on things you can actually do in your everyday work, and not really talking too much about theory, though I do want to give you a background in human rights law. I also want to warn you or just let you know that my wheelhouse is economic, social, cultural rights. As a former legal aid attorney, I focus mainly on civil practice, obviously. So a lot of this is geared towards the civil side. It doesn't mean it's not applicable to criminal cases or other types of, whatever you can think of immigration. But you want to just keep that in mind. And if you have any questions, interrupt me. I'm going to try and use as few acronyms as possible. But sometimes I do use acronyms, and I apologize. Okay, so let's get started. This is what we're going to cover in the next hour or so. Then later today, we're going to go into more about actually building a human rights argument and where you might want to use it in a court case or before a policymaker or legislative advocacy. But today, this morning, this first session is just sort of the Human Rights 101. And you're going to hear me make some arguments about why you want to use human rights in your work. So, the Center for Human Rights and Humanitarian Law, this is where I work. I've been working for the last 3 years or so. We're not a clinic, not an academic research organization. We really focus on training practitioners. So we're at the law school. We have students who work with us, but we don't do much training or education of students. It's mostly practitioners. So we have a project working with human rights clinics and human rights attorneys in Colombia, the country. We have a project where we bring in disability rights fellows from all over the world to sort of look more in a focused manner on the intersection of human rights and disability law. So it's really interesting. It's been great to work there, and there's all sorts of other great people who work with me there. So the project that I've been working on is the local human rights lawyering project. But we have these other projects as well, an anti-torture initiative, the UN Special Rapporteur on Torture, Juan Mendez, who just made a great statement yesterday about police brutality in the U.S. You should look at it. Works out of our office, and his team work is based there. It's just really interesting. So the project, the local human rights lawyering project, which led me to come to this training today, was a project that was started in October of 2011, so it's pretty new. And we were started by just focusing on 2 legal aid partners. Our whole goal of the project was to integrate human rights into every aspect of the work of legal aid attorneys and all the staff, so not just the attorneys, social workers, admin, IT, everybody, at 2 organizations. They were Texas Rio Grande Legal Aid and Maryland Legal Aid. And that project has since sort of expanded and also contracted to the point where we now are working with legal aid organizations across the country, and I've done trainings like this: California, Texas, Florida, New York, New Jersey, Maryland, and then virtually in most states in the U.S. Through webinars. I am actively speaking with legal aid attorneys and other attorneys about specific cases all over the country, which is really interesting. But it started with these 2 legal aid organizations, and it started by funding full-time staff attorneys in those organizations. Their whole mission was to provide training, support, and technical assistance with our help to everyone at the organization. I was funded by the Ford Foundation, really interesting. This is when we developed our handbook, which you all have a copy of. We also had a variety of different consultants. That handbook was edited by me, but drafted by many different folks. Legal aid attorneys, human rights attorneys, academics, It's drawn from many of the other materials that Steve has made available to you from Columbia and from Northeastern universities, law schools. It's sort of it was a great collaborative project. So the overarching goal of the project, and this echoes our goal here today, was to integrate human rights into the everyday work of staff at partner organizations. So what do I mean by that? So yeah, legal arguments. We wanted attorneys to go to court and talk to local policymakers and make human rights arguments. That doesn't necessarily mean, and as you'll see, citing to human rights law. It could just be using human rights language, like housing is a human right, things like that. Just sort of saying the words. But it also meant to actually putting citations to international treaties in legal briefs. We also worked a lot about how to integrate human rights into the client-staff relationship and into staff-staff relations. So really thinking about what it meant to be a human rights attorney as opposed to a legal aid attorney or a public interest attorney or public defender, and how that might change how you interact with your clients, how you interact with your colleagues, what the different office systems, how it might change office systems, everything from intake to case selection to case strategy, all of that. And we're going to talk about that a little bit later this afternoon. Often it doesn't mean making any change. Maybe everything you're doing is really in line with human rights principles and your goals. Sometimes it's more about stating those goals or those principles or how you work out loud so that your clients know where you're coming from, so that you're being a little bit more transparent. And I'll give you some good examples of what some other folks have done and what actually we've done in our office around trying to bring human rights principles into our relationships and our everyday work. So, resources provided by the project. The handbook, which you all have a copy of, in-person trainings like this one today. Also want to mention on our website, which I'll give you and you'll become familiar with, there's webinars, really a good group of webinars with PowerPoint presentations on these individual issue areas. A couple of ones to take a look at: international legal research. I'm not going to be able to give you a whole presentation on how to do international legal research. The one thing I'm going to tell you is you can't use Lexis or Westlaw. You also don't want to just Google when you're looking for international cases, when you're looking for treaty how to properly cite a treaty in a local or state court. This webinar that's available on our website is done by a clinic director at University of Texas, Ariel Delitsky. He does a great job giving you some good sources, very easy, free sources of where you will find cases, where you'll find treaties, where to look if you're looking at a specific issue like workers' rights or police brutality. How do you find all the treaty body recommendations, conclusions on those issues? How do you find all the international cases from the European Court to the African Commission to the Inter-American Commission? There are places where you can find all of that very easily, and so he does a great job of going through that. So the other thing I can say is the handbook does go into where to find international human rights law, but you'll have to read it, and there's the presentation that Mr. Litsky gave was really great. So also want to let you know that in tandem, these presentations that I've been making and that my team has been making all over the U.S., that for the past several years, the Aspen Institute has been training judges, state court and federal court level judges, in international human rights law. The American Society of International Law has published an international law bench book. So there are judges out there who not only have a bench book, but they also have been to week-long trainings in using human rights law in the U.S. That has ceased as of about 6 to 9 months ago. but they, I think due to funding, but the wife of Lou Hankins, which was he was an amazing human rights law professor out of Columbia University, Alice Hankins, was doing these trainings. And so just know there's no public list of judges that have taken these trainings, but if you know a judge or you know a law clerk, you could ask them if they, and there have been judges from Oregon, there's been judges from every single state, so finding out who those judges are, they will have maybe even more knowledge of how to use human rights law at the local or state level than you do, and those are the judges you might want to think about making these arguments in front of. So, so the introduction to the handbook, I'm just going to go through this really quickly, and for those of you that have it printed out or on your device, you might want to open it up. The idea is it aims to get practical and usable human rights information into the hands of legal aid attorneys. So it's supposed to be drafted in simple language. We aimed for 8th grade reading level. Sometimes it's a little over that, but that was what that's what the authors were supposed to be aiming for. We wanted to have it be usable every day. And there's a lot of repetition, so you can just use one chapter instead of reading almost 300 pages of it. I want to just say, and I'll say this again, we encourage you to cut and paste from the handbook. This is not something where we don't want you to, where this is copyrighted or some. You can use anything out of the handbook. You can literally cut and paste the sample arguments into a brief or into an article. Please use it however you like. The way the handbook is set up, you can cut and paste the citations from, if you want a certain article on a certain convention, you can cut and paste it from the handbook into your brief. We won't, this that's what it's for, is to make this as easy as possible. So the handbook itself is broken down, actually similar to how we're doing some of our presentations today. We start with an overview of the project, the Local Human Rights Learning Project and the Center for Human Rights. Then we go into a Human Rights 101, very basics, and then an advanced Human Rights 101. It's more specific. It goes into sample human rights arguments as to why human rights law is relevant to local courts. It goes into sample opposition arguments, actually cut and paste from briefs and complaints, replies to the complaints filed in U.S. courts. So what you can expect from the opposition when you're making a human rights argument. And then part 5 is where you go into the specific legal issue areas. And at this point, this is a working document. It's always being built upon. At this point, we have 13 different issues that we've gone into depth. We still have a few more we would like to cover if I ever get a chance. And I welcome suggestions. So if you have an issue area that you really would like to see covered, it's possible we can make that happen. The Right to Counsel section was just added last spring. So I think maybe it was July, we published a new edition of the handbook. So that's another thing, is if you haven't looked at our website or the handbook in a while, maybe in 6 months, check back in. There'll be a new section, there'll be more edits, there'll be more sample arguments for you to take a look at. So I can also tell you some of the more popular sections in the handbook in terms of what people are using all the time: freedom from domestic violence, housing rights, the immigration sections, and the right to counsel section. Some of the others are very, very specific to the type of work that you do, like the international child abduction section is very, very specific, but written by an expert actually out of Texas, Rio Grande Legal Aid, but who has practiced child abduction cases for 30 years and is also now an expert, like a noted expert at The Hague, and has helped draft amendments to the Hague Convention. She's really terrific, and she drafted that section for us. I think it's the first of its kind, so if you have anything to do with child abduction, I would take a look at that definitely. Other thing about the handbook, really just it's full of hyperlinks to the full text of the treaties whenever it's available. It also is searchable, and if you click on the table of contents, it will take you to that chapter. It's really, because it's so bulky, we tried to make it as easy as possible for you to use. Okay, I'll pause there. Any questions on all of that? I know this is a little tedious, but I think it's good to take you through it because you probably won't take a look at it if I don't walk you through it. Questions, comments? Okay, so now we get into the fun part. What are human rights, and why are we talking about human rights today or ever? So this is the definition that I use of human rights, stemming from the Universal Declaration of Human Rights. I hope everybody got a copy of the little blue booklets, Universal Declaration of Human Rights. If there's not enough, I can always send out more, but I think it's a handy way to sort of, so the Universal Declaration of Human Rights is sort of the overarching document that led to the drafting of all of the core human rights treaties. And so that it's a declaration, so it's not binding, but it's meaning that all various countries have signed it, but it's just sort of a framing document, not a we are agreeing that we are going to do anything document. But because all of the core human rights treaties have stemmed from that document, it has very simple language, sort of, title language for all the different human rights. So it sort of gives you a little snippet, gives you a little snippet of all the different sorts of rights that we're going to talk about today. So human rights are universal legal guarantees protecting individuals and groups against actions that interfere with fundamental freedoms and human dignity. So some of the important characteristics that I'm pulling out of here, they're legally protected. These are, human rights law is binding on all countries that have signed and ratified the treaties, and even the United States has international obligations under the treaties that it has signed and ratified. We'll talk about what those obligations are and the limits on those obligations, but these are legally guaranteed rights. And it's not just to, they're not just to protect, they're to fulfill and respect the human rights of individuals. So these human rights law obligates states and state actors. So generally we're not talking about private disputes, though there are times when human rights law does enter into private disputes, and I'm going to give you some examples. But generally we're talking about obligations of state and state actors. So human rights cannot be waived or taken away. We say that they're non-derogable. So even in times of emergency, the human rights are inherent and cannot be interfered with. Human rights are independent and interrelated. So you can think of the right to education, right, to a child. Their right to education depends on their right to housing, their right to food, their right to health care. Right? If they're not healthy, fed, and have shelter, they're not going to be able to learn properly. Right? So the human rights, but that's true of all human rights. So you can think of the right to freedom of assembly, also is interrelated with the right to housing, the right to food, the right to health. If you don't have food, you don't have shelter, you're not going, how does your right to freedom of assembly even, how can it be actuated if you are so not healthy that you can't even get up and assemble? So another aspect, they're universal, so they apply to everyone. Your citizenship status does not matter in the human rights world. Your documentation does not matter. Whether you're a child, you're elderly, any ethnicity, race, universal means that human rights are inherent to everyone. And then the last, they're all American. So Eleanor Roosevelt drafted the Universal Declaration of Human Rights. And the U.S. was very a strong, pushed out and got other countries to sign the Universal Declaration of Human Rights. It's sort of a human rights, we were the human rights framers, you could say, though that is often lost in conversation today, and we tend to think of it as human rights apply outside of the United States, not inside. Human rights are something that happens in Bolivia, in Bhutan, but we don't need human rights here. We are just fine with our civil rights, right? But it's actually, we just have to remember that it came from the U.S. and it's still, many of us think of it as a U.S. tradition. Questions about the definition of human rights. So sampling of human rights, right to non-discrimination, right to self-determination, these are all from the Universal Declaration of Human Rights. Freedom from torture, right to privacy, right to special protections for women and girl children, right to adequate standard of living, that's the right to housing, right to health care, right to social services, and there's many, many, many more. So we can also think of human rights not just in terms of law and legal obligations, but human rights as values. So they remind us that all humans deserve to be treated with dignity, and dignity is a sort of the highest principle in the human rights world. It's sort of highest or the most base, right? It underlies everything. So when we talk about bringing human rights into the staff-client relationship, or thinking about office systems, whether you work in a private law office, a legal aid office, government office, that's when we're really talking about values. Human rights is values. So the right to privacy, the right to confidentiality, the right to participation in your case or in your office system, right to fair wages. Human rights can also be thought of as tools. So we often talk about the toolbox and how human rights are an additional tool in your toolbox. So we're not trying to ask you to, replace anything that's already in there. This just might be one additional tool that you can use, hopefully every day, but at least once in a while. Human rights is also a movement. So when we talk about the right to housing or the right to education, we're not just talking about the right to housing or right to education here in Portland or here in Oregon or here in the United States. We're tying this local issue, this local dispute to a worldwide issue. So we'll talk about evictions in Ireland. We can look at a lot of parallels with evictions, so thinking about evictions of people who are nomadic in Ireland. We can still look at the same thing, people who are evicted in Spain and people who are evicted here in the Midwest, all sort of looking at the same issue. And we can use human rights and human rights language to tie the issues together. Okay, so why human rights? So I'm going to give a bunch of different arguments about why human rights is relevant to your work. I may be preaching to the choir, but I think it's sometimes important to think about which of these arguments most resonates with you and your work, and try and articulate why human rights in your own words. So that's something I'm going to ask you all to do. So I'm going to give you a whole bunch of different arguments, and then you can tell me which most resonates with you in your work. And maybe it's a few different arguments, but maybe it's just one, or maybe it's none. So human needs and human rights. This is, again, sort of more looking at economic and social rights. But why do all people need to live in dignity? When, looking at trying to think about needs like housing, food, healthcare, not as just needs or something that we are going to provide because we're nice people, but as a right, something that everyone deserves and so everyone has a right to obtain, and that without those needs being met, that it's the same as if we didn't have freedom of speech, or we didn't have a right to a fair trial, things that we sort of uphold here in the United States as the sort of prime thing that we have a right to. I think also human rights help fill in gaps where domestic law falls short, and I'm going to give you some specific examples of where that is. But I think that they also can provide an interpretive guide to U.S. law and to local law. So sometimes we'll have a case of first impression or an issue we've never seen before, and it'll turn out that there is an international case or there is a treaty provision that's exactly on point, and it's not something we've considered before. And I think that happens a lot more often than we think. So it can be a way to fill in where we don't find case law or statutes here in the U.S. It also can be a framing tool, so again, trying to connect to a broader movement. When you take a case dealing with wages and you start to talk about unfair pay or no pay, and you start to turn it around and use language like slavery, it can really change the case and your communication about the case and maybe the outcome of the case. So it puts it in a completely different context, sometimes shock and awe the policymakers or the judges that you're trying to get through to. Also, again, helps to legitimize economic, social, and cultural rights. I talked about this a little bit, but it can build jurisprudence, especially on those issues. And last, I think human rights law can help you go beyond law, really get to justice. And this is something that at Maryland Legal Aid has become sort of a mantra for them. But they really think a lot about what the limitations of their work are and how the individual cases, the laws that they're limited to may not achieve the goals of their clients so often at the time. But they can talk about human rights and what should be, what is morally right, or what human dignity really looks like using the human rights framework, and talk about how, and really connect with clients that way. So a client will come in and say, I don't think I should be evicted, but you can say, I don't have, you client, I don't think you have a great case, you haven't paid your rent in 16 months and you don't have any money to pay the rent, and we don't know how to help you. But yes, I do think that housing is a human right. Yes, this is not the way it should be. Yes, these are ways you can work towards helping us make housing be a human right, whatever those ways are. So I think it's a way to connect in a different way with clients and really get to justice. So now we're going to go more into the technical human rights law aspects. That doesn't mean I'm done with making my arguments about human rights law being relevant to your work, so stay tuned, but those are just some starting arguments, a little more general than the ones I'm going to get to in a few minutes. So, human rights law sources. Start with treaties. What are treaties? What's the definition of a treaty? Anybody want to throw out what's a treaty? Yeah.
It's an agreement between two or more nations.
Yeah, exactly. A contract between countries, like between governments of countries. Exactly. Okay, so next, and that obviously we're talking about a sign for the purposes of using international law in the U.S. We look at signed and ratified international treaties, and we're talking today about human rights treaties. There's obviously many other types of treaties that the U.S. enters into with other governments, and it may be bilateral. There's all sorts of, but we're really just today talking about human rights treaties having to do with the rights of persons in different nations, and we're going to be talking about treaties that are entered into by many, many countries. Ratification of a treaty. Does anybody remember from wherever you may have learned this? How do you ratify a treaty? I was going to say law school, but I know not everyone.
Typically, it would be by a vote of a majority vote of elected representatives of the people.
Yes, and under U.S. law, who ratifies the treaty?
The Senate.
And how many senators do we need to ratify a treaty?
2/3.
2/3, which is
66.
67.
67. We need 67. Okay, pop quiz. Which human rights treaty got to 62 votes last year or the year before, but was not ratified by the Senate? Just 2 years ago.
Yeah, was that the service under 18? Which one was it there?
Very new. It's the newest sort of core human rights treaty. I know.
Disability?
Yes, the
Disability, yeah.
Convention on the Rights of Persons with Disabilities got to 62 of 67, but did not pass in December of 2012. It was voted on again earlier this year and didn't pass, but that is another whole story. We have not in the U.S. ratified a human rights treaty, a core human rights treaty since 1992. So it's been quite a while. That's the closest we've come. Hopefully that treaty will eventually pass, but we'll talk about that.
So if the treaty is signed by the president or whoever negotiated
Yes,
the treaty,
the executive branch, yes, the president signs it.
but it's not ratified
Mm-hmm.
by the Senate, then it's of no effect?
No, okay, so that's a good question. Let me just skip ahead a little bit. I have a great citation. Let's see. So the idea is this is a sort of, I guess I don't have it right here, but the idea is when you've signed and not ratified a treaty, you still have to act in a way that does not go against the core purpose of the treaty. I guess that's a good way to put it. So that's your sort of obligation. And what all of that means has been interpreted many times by international bodies and foreign courts and the U.S. court, but the obligation, this is not the right citation, but the obligation would be you cannot go against the object and purpose of the treaty if you've just signed and not ratified. Now we've signed many treaties that we have not ratified. So these are the treaties that we have ratified. So there's 3 core human rights treaties at the UN level and then 2 optional protocols. The International Covenant on Civil and Political Rights, International Convention on Elimination of All Forms of Racial Discrimination, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment, and then these 2 optional protocols on the Convention on the Rights of the Child. Now, we have not actually ratified the Convention on the Rights of the Child itself. We are one of 3 countries, although, well, 3 countries, I think, we may now be 2 countries that have not ratified the Convention on the Rights of the Child. Anybody know what the other 2 countries are?
I think Israel's one.
Somalia,
Somalia,
and South Sudan, although South Sudan may have ratified, I'm not sure. But yeah, we have ratified the Children in Armed Conflict and the Sale of Children. We'll talk a little bit about why we might have not ratified the Convention on the Rights of the Child. But some other treaties signed by the U.S. and not ratified. We have signed the Convention on the Rights of the Child. We signed the Convention on the Elimination of Discrimination Against Women, not decimation. I spelled that wrong. Convention on the Rights of the Persons with Disabilities, Convention on Economic Social Rights. There's many others. Those are just some examples. But so, what happens exactly? I can tell you what happens with the Convention on the Rights of Persons with Disabilities. The executive branch, the president, signs. He submits a package with reservations, understandings, and declarations to the Senate. The Senate then argues about what exactly the ratification package will look like, the legislation that they'll pass to ratify the treaty. Then they vote as to whether or not to ratify. That's how it worked with the Convention on the Rights of Persons with Disabilities. So there's quite a bit that goes into ratifying beyond just the vote, and it's the devil is all in the details, right? Okay, so back to our sources. Treaties, contracts between governments. So we have customary international norms. So these are patterns and practices at the international level that are recognized by universally, basically. Anybody have any examples of what anybody take international law? Yeah. Okay, so this will be totally in your customary international norms. Give me an example of a customary international norm in the human rights context. Something that would be prohibited, maybe.
That used to be torture.
Torture, yeah, torture. Yeah, we call it, this is the other word for customary international norms, jus cogens. If you took international law, torture. Yes, still we would consider that a customary international. Used to be. Yeah. Yeah.
Things.
Go ahead.
So that customary international law is a set of these principles that the majority of states agree to are prohibited, but if a country has been a consistent objector to something, they're not technically bound by customary international law. Where jus cogens is even a narrower subset of customary international law, and it's those things for which no country can violate regardless.
So is customary international law, if you think about it, similar to torts, for example, so when we go into courts, we have statutes that we're filing suits based upon. But then there's this other kind of judge-created law, which I guess you would say are torts, which also give people causes of action. So is customary international law, can you think of that in that way, or is it really different, judge-created?
It's not, so customary international law is not judge-created. It comes from more looking at, so it's a little bit different because like the judge-created law isn't looking at like the practice of all the states in the United States, for example, right? It's more that set of judges or that judge decides that this is the way the law is, and then because of the way our constitutional law system works, that becomes the law, right? But customary international law is more looking at the patterns of practices of all the countries and then Jus Cogens, but there are international bodies and there is conventions on how you interpret conventions, the Vienna Convention.
Put up a better analogy about what is international customary international law might be what we think of the law of custom with regard to merchants and in commercial law, where there's no statute necessarily, but over time, because people behave in a certain way, it's become expected that you're going to behave in that way, and then over time, that gets ingrained into the law. It's a type of common law. That just might be a little bit better of an analogy.
Yeah, in Oregon, probably the most well-known use of custom in the law is the decision of the Oregon Supreme Court some 30 years ago in State X. Rel. Thornton v. Hay to declare that Oregonians had a right of public access to our beaches based on custom.
That's a good
It was
example.
a custom of the people
Yeah.
to have public access to beaches, therefore we have it.
The other thing is just, at the end of the day, customary international law is what the judge that you're in front of agrees that it is. And you make arguments about whether or not something is customary international law, and you make that argument by saying, hey, the restatement of foreign law says that it is, although that's not binding, that's persuasive. You would say all these treaties, you know, this is stated in all these treaties, that's evidence, and then evidence that states agree that they can't violate it. So you're making an argument to a judge, and whether it's a judge on the international court or a domestic judge, they ultimately say whether, yeah, we agree it's customary international law or not. It's one of those sorts of things.
So you're in court, and let's say that we hadn't ratified the Convention on Torture, and you're doing some case based on a prisoner who's been tortured, and you're wanting to cite international law on top of whatever other tort you might cite. So you're saying as a matter of customary international law, torture is, or the prohibition against torture is a matter of customary international law. And the judge says that you're in front of, well, who says it's a matter of customary international law? Do you have to have a decision, or is there some, who decides, other than the judge you're arguing a case in front of, that something is a matter of customary international law?
Really what they're looking at for the most part is customs, practices of other states. So in the Roper v. Simmons case from 2005, which banned the sentence of the death penalty on juveniles under 18, the court, Justice Breyer, looked at the practices and custom of other nations and looked at the fact that we had not ratified the Convention on the Rights of the Child, but that every other member nation of the United Nations besides Somalia and South Sudan had, and said that we were, very much paraphrasing, that we were outliers in that way. So that was basically looking at what the international community thinks of that practice and what the pattern and customs are. But let me go in. Yeah. So I think that would be sort of the answer. The customary international, using customary international law, customary international norms is not an easy, probably, thing to do for most attorneys, and I think because you're going to get a lot of questions about it, and because the judge may not be used to making a decision about what is custom and practice, especially at a local or state level, unless it's a court that is familiar with international law, Jus Cogens, or is a court that has, had a training, the judges had a training on international law. It's a much easier thing to be able to cite to a treaty or a source, which you can for customary international law, because there's many international courts and U.S. courts that have looked to custom and practices. but the good thing about customary international norms like torture is that you don't have to, in the Juice Kogan's context, where you don't have to, it applies to the U.S. whether or not we have, if we have consistently objected, we still are prohibited from torturing under international law. So that's the good thing about customary international law, is that you can't get out of it if it's just Kogan's.
I think that there has been an effort made in several contexts. One of them is in sexual orientation discrimination cases,
Yes.
same-sex marriage, juvenile offenders, over the course of the last 15, 20 years, in Supreme Court, U.S. Supreme Court arguments to, in those briefs, set forth what is the custom internationally, to kind of make the argument that what we need to do in this country is to recognize that there's an evolution in the law elsewhere internationally, and we ought to be following that. And Justice Kennedy, of all people, is one of those people who seems to be sympathetic to that argument. He teaches, like so many Supreme Court justices do, in Europe each summer, apparently.
When you can make cutting-edge arguments to say, this is an evolving customary international law norm. The right of family unity, for example, I would say most people would say is not yet recognized as customary international law, but many people would say it's an emerging customary international law norm based on, but again, you're making that argument to a judge, and you would put evidence before the judge saying, for example, these treaties all recognize the right of family unity, and most of the treaties do, that most countries acknowledge and practice, and that the right to family is very important, and so you'd be making those sorts of arguments. So it isn't it isn't static, it is evolving, and that's very important to remember. And as Lauren said, sometimes it's going to be easier just to point to a treaty, but it also, that depends on the context and what you're arguing. I know when I talk in my session about the Alien Tort Statute, for example, and the role of customary international law in domestic legal systems, which I'll cover later, we can talk a little bit more about it. In those situations, you're better off actually pointing to customary international law than a treaty itself.
This is, again, we're going through all the different types of human rights law sources. This is important because I handed you all a copy of the Universal Declaration of Human Rights, and we'll also be talking about various resolutions that the UN General Assembly has passed. So these are issued by international bodies. It could be the UN General Assembly, it could be the Inter-American Commission. There's different human rights bodies and systems that I might get to later this afternoon. These are not binding, but they can provide evidence of agreement by the international community, so going towards customary international norms. I also want to mention, when we talk about customary international norms in this argument about practice, this is similar to when you talk to a state court and you say, look at, for example, for Oregon, look at what the state of Washington has done. Look at what the state of California has done. Look at all the states around you. This is what they have done. Why don't you do that? Or why not? Don't do that. So it's sort of looking at the practice of sister states, or you could be looking at the practice of sister counties if you're at a very local level, or different cities, that kind of a thing. So we can also look at international case law from foreign courts. So the Supreme Court of South Africa, the Supreme Court of India, they have terrific decisions based in human rights law. Now, enforcement of those decisions is a completely other conversation that we're not going to get into, but great language, fantastic. You can also think about the European Court of Human Rights, the Inter-American Court of Human Rights, African Commission, the Inter-American Commission. There's great case law coming out of all sorts of different international bodies and courts. Also U.S. courts. Stephen mentioned the Sterling v. Cupp case in the beginning introduction. That's a case cited by human rights attorneys all over the U.S. when we talk about how state courts have interpreted their own state constitutions using international law. So I think that we don't want to overlook U.S. case law as well in terms of looking at international law. And then we have general principles and guidelines, and this is something that will come up through some of our presentations. These are more like I would compare it to a restatement of the law, or some kind of framework that will hopefully turn into hard law later, so sort of soft law, where you may have a group of countries or a group of experts who have put forth these principles and guidelines, but they're not binding and they're not necessarily even agreed to at sort of a regional level, or even definitely not an international level. There's no there's no bigger agreement about it. So ratified treaties as supreme law of the land. I'm just going to bring us back to our Constitution and the Supremacy Clause, which does state that the Constitution and the laws of the United States, all treaties made shall be the supreme law of the land. So it puts the treaties up there at the same level as the Constitution. So why aren't we using treaties all the time in our work, right? And this is why. It's because the U.S. centers reservations, understandings, and declarations when we ratify a treaty. And these are in the legislation passed when ratifying the treaty, but also when we submit the ratification to the UN, it goes into the record at the United Nations in terms of, so it's basically, this is how I always think about it. Say we're signing a contract, we're a bunch of different people signing a contract, and we are signing the contract after everybody else did, but we sign it and then we say, but, and we write a whole bunch of different things that disagree with a lot of what the contract says. But nobody else then has to agree to any of that. We just get to unilaterally say, when we sign this contract, we're going to disagree with all these things in the treaty. So it's not, our version of contract law in the United States would completely disagree with how this reservations, understandings, and declarations things work.
And for these reservations, understandings, and declarations, must they be entered simultaneously then with either the ratification or signing, or is that something that can be done after the fact?
It has to be done, I don't know the answer to that. I think it has to be done with.
I think that's a good question. I actually don't know the answer to that. I've never known it to not be at the time the Senate ratifies it. And then when the ratification is delivered, they say these are the reservations. Whether or not it could happen afterward, that's actually a good question. I don't know. I've never seen it happen.
But basically, So see, these are some examples of what the U.S. does. And the reservations, understanding, declarations for each treaty that we've signed are available on the humanrights.gov website and also in the UN treaty ratification. They have every treaty, the UN treaty system for every treaty keeps track of which states have signed, which states have ratified, and then has a complete copy of the ratification package online. So you can find that it's a lengthy document, so these are just some examples of what it says. So treaties are non-self-executing. We enter that with every human rights treaty that we have ratified. It means that the so there's thousands of law review articles about what non-self-executing means, and you had probably an entire section of your international law class about it. Bottom line, Congress must enact implementing legislation separately. So not only does Congress have to ratify the treaty, they also have to pass some other legislation that implements the treaty. So it's not just good enough that we have ratified the treaty. For the U.S. to consider it binding, they think that we also have to enact implementing legislation or to use it, yes.
Is that true generally or only when a RUD specifies that?
No, this is what U.S. specifies this. This is not a thing that is true as a true principle of international law. The U.S. states this. That's not true of all countries, but it is true of all human rights treaties that the U.S. signs, and ratifies.
Do you mind if I clarify my question? Are there other treaties that the U.S. signs? Is the default for a treaty within the U.S., is the default status self-executing or non-self-executing?
Yeah. So
the United States has something called a dualistic system. So the default is that it's non-self-executing, and that the U.S. has to take additional action. That's the default. Treaties themselves sometimes will speak to this issue and will say, this is supposed to be kind of self-executing or not. So that would be the next place that you would look. There have been in the past some courts that in the United States, these were older, I think in the early 1900s, mid 1900s, that kind of said, we think that the intent of this treaty was that it was self-executing even in the United States. Because of some of those cases, this is why the Senate now, as Lauren points out, routinely says with each one, it's not self-executing, just to make sure that there's no confusion about that the United States has to take separate action. It is important to note, though, that when the United States does ratify a treaty, what that means is that you're agreeing with those other countries that you, in fact, are going to implement it domestically. Okay? But you have to wait for Congress to do that. Now, that is a slightly separate issue about whether or not you have a private cause of action under the treaty. And I don't know if you're going to get onto that or not. I will also talk about it. But, okay, great. I'll let you cover it.
Yeah.
I mean, Indian rights treaties are self-executing, right? I mean,
Yeah, okay,
That's very
yeah.
different. I mean, not very different. It's different.
So that's actually what I was going to say. There are lots of treaties that the U.S. signs and agrees are self-executing, but not in the human rights context. So I don't know, I don't know the answer to how many treaties we've signed ever and how many we have agreed or self-executing and how many we haven't. But in the human rights world, all are considered non-self-executing for the U.S., not for other countries. One of our human rights treaties does have implementing legislation, just one. Which one? And Gwen can't answer. Anybody know? The Torture Victims Protection Act is considered the implementing legislation for the Convention Against Torture. It's the only implementing legislation that we have for our human rights treaties.
Unless you consider the Genocide Convention.
I wasn't considering,
You didn't think of that, yeah, because that's more of a criminal, but that is.
Yeah.
And then the trafficking protocol
Right.
is, I would consider, a human rights treaty, and that maybe, we could have put up on that list, but that's, and that has implementing legislation, the Trafficking Victim Protection Act.
So, okay, so we're going to be more precise. In terms of the core human rights treaties, yes.
Question. Has there ever been a case where, say, a reservation understanding or declaration that's been sort of adhered to a treaty has been challenged for providing such modification or so much wiggle room that the obligations under the treaty are just sort of changing?
Yeah. There have been, I think the executive director of the Center for Human Rights where I work is all about trying to challenge. I think that there haven't been any successful challenges.
Yeah, it's the one thing to note about reservations is that the law of treaties, which comes from the Vienna Convention on Treaties, which the United States has not ratified, but have acknowledged as customary international law, says that when a country makes a reservation on a treaty, it can't go to the heart of the treaty. So for example, there are certain Middle East countries that have ratified the Convention on the Discrimination of Women, but then have reservations on issues of family law and property. And some other countries would say, well, you can't do that because that's a violation of the law of treaties. What the therefore is I think still unresolved, at least on an international level. Does that mean that the country therefore is just not a member of the treaty because you can't do that? Or is it that, no, they still have to agree to abide by the treaty once they've signed it? So on the international level, there have been challenges in front of courts with countries that have made these reservations. But I don't know the answer to the U.S. courts.
No, the U.S. I think there have been a couple of challenges, but completely shut down in the very first level of court. So my director is all about bringing a U.S. challenge under U.S. constitutional law.
One very well-known reservation, in addition to the one about the self-executing that comes up a lot if you do human rights work, is
The ICCPR, also prohibits not just torture, but cruel, inhumane, degrading treatment. And one of the reservations that the U.S. has on the ICCPR is that it agrees with the prohibition on cruel, inhumane, and degrading treatment only to the extent the United States Supreme Court has found that certain conduct is cruel, inhumane, and degrading treatment. And so that's a common one where the reservations are trying to limit the obligations to what the obligations are under the U.S. Constitution and not broader than that.
Yeah, so no treaties prior to go no further than the corresponding U.S. law. So no private right of action, this means that you can't bring a private claim in U.S. court, say under the ICCPR, I'm suing because my right to freedom of assembly, has been violated. So no private cause of action, when you would think of.
Unless Congress gives it to you.
Unless Congress gives it to you.
Which it has under the Torture Victim Protection Act and the Trafficking Victim.
So I'm going to do these last arguments and then we're going to pause here for a break because I know we're running over time, Mr. Timekeeper. So how is human rights law relevant to U.S. courts and policymakers? I am going to make 5 arguments. These are arguments that were made by Professor Martha Davis out of Northeastern Northeastern School of Law, and see what you think. These are expanded upon in the handbook into sort of like, paragraph, page-long arguments. But these, I think, are great examples of how you might argue to a court or a policymaker that human rights law is relevant. And this goes to my question to you, or my, ask of you to think through why human rights is relevant to your work. What are the arguments that really resonate with you? And I'm going to ask you about this later. So how is human rights law relevant to U.S. courts and policymakers? The first is some state constitutions may support, if not compel, looking to international law for legal interpretation of domestic law. The Maryland state constitution has a supremacy clause, just like the U.S. Constitution, noting that treaties should be looked to by the state court and state legislature. Very interesting. I don't know if Oregon, I don't think it does, because when I was doing helping with the human rights in Oregon document, I looked at to see if there was. I think it doesn't, but that's one thing to look at is your state constitutions. The second one, human rights jurisprudence may offer precedent and models more on point for the case than anything in the federal system or sister states. I talked about this a little bit already, and I'll give some more examples this afternoon of specific cases where I think that the language is more on point than anything we could find locally or nationally. State courts should interpret U.S. laws consistent with international law wherever possible. This is the Charming Betsy case that led to the Charming Betsy doctrine that I'm sure you talked about if you took it, or you should have talked about if you took an international law. Of course, still valid green light U.S. court decision from 1804. Fourth, where there's no controlling U.S. law, state courts should look to customary international norms for guidance for its decision. I'm citing to Roper v. Simmons, which is the juvenile death penalty case we were talking about a little earlier, but there could be other cases, including Lawrence v. Texas, one of the case that struck down anti-sodomy laws. That also.
Is that a quote?
No, that's not it's not a quote. I have excerpts from, in the next part, we'll look at the actual language. That's paraphrased. That's Martha Davis paraphrasing. And then 5, state courts should be part of the transnational dialogue on human rights simply because it's a vital conversation that promotes universal values. Again, I think that each of these relevancy arguments could be made in different cases in front of different judges. You know, usually when I'm doing this presentation, the ones with citations are the ones that resonate more with the lawyers in the audience. But I have seen all of them used, I think, very successfully and at the state court level. So we're going to pause here for a break because we're running over. But just an example, this is the third argument that Charmy Betsy sort of expanded, and this is an excerpt from a brief that Texas Rio Grande made. So this is their sort of argument as to why the court should look at human rights law or international law in its decision-making process.
Okay, so is everybody still alive here? Okay, that's good. There's obviously a lot of information to cram into a relatively short period